Hello, and welcome to another edition of Coffee Talk with attorney Brian Lerner. In this particular episode, I'd like to talk about a situation that you might find yourself in that you don't like, but you may as well take the advantage of it and do what you can do. So let's say you're just sitting at home one day talking to the kids and, just relaxing on the recliner, doorbell rings, and you walk to the door and you say hello, and you think it's some nice guy selling chocolates. He asks for your name. You go, "This is me." And he goes, "Here, you're served." And you find out that your long battle, for example, of administering a trust or something similar to that has just hit a snag, and your brother or some other family member has decided to bring you into court to either determine where an asset is to go, to determine who's the beneficiary. I mean, just because it's not a will and just because it's a trust doesn't mean you won't find yourself in court, okay? And sometimes it's better that way. I mean, honestly, sometimes what happens is you go back and forth and you fight up and down with like the other trustee or the beneficiaries, or somebody on the other side gets an attorney, and you go back and forth. And for example, instead of the attorney trying to resolve the matter with you, to take the high road, to find out what really needs to be done, the attorney hides things, the attorney stonewalls you, the attorney doesn't let anything go forward. So when that happens, honestly, it's almost like a blessing in disguise to be brought into court, because the judge could care less about trying to stonewall things. The judge is going to hear the facts. The judge is going to hear the law. And as long as you have the facts and law on your side, you'll win. Okay? And even if you don't, at least there'll be closure to the matter. So at this particular juncture, if you get served and you have to go to court, take advantage of it, because what you can do is you can start discovery. And because you are the respondent to this particular motion, you don't have to wait 20 days. You don't have to wait until you answer. You can file right away the discovery. You can do discovery on third parties, okay, meaning that not necessarily the petitioner, but let's say that somebody somewhere is trying to hide something, and let's say it's a beneficiary and they're trying to hide all kinds of stuff from you, and let's say it has to do with a safety deposit box. So the safety deposit box will actually make it so that before you were relying only on the particular beneficiary to divulge the facts of where the safety deposit box was, what was in there, was it part of the estate. I could go on. And of course the beneficiary lied about everything, said, oh, he didn't go in there, he doesn't know what's in there, and even if he did, he knows it's just a piece of paper type thing. But when you've been served with an action in probate court, you now have the ability to subpoena from the bank the necessary records in about the safety deposit box. As long as you follow the proper procedure, they can object, but still you can do a motion to compel and whatever. You can get the information you finally need. And then you go to court and let the judge make the decision. And that's why sometimes it's better just to be in court. I know that none of you particularly like to hear that, but that's the reality, because especially if you get these cases where the attorneys are so gung-ho on the other side that rather than administer the estate, they do everything in their power to maximize what their client gets, which could be contra to what the trust wants, and normally it is. So if you like the video, click like, subscribe, and also you can call my office for a free consultation anywhere in California. Okay, more on the coming videos.